Morning. Please be seated. This is the time set for oral argument in Jules against Lund, our cause number 1CA CV130621. Counsel, we're quite familiar with the issues in the case before us today. We've read the briefs and conferred, so you can bear that in mind. Our oral argument today will be videotaped, and each side will have 20 minutes to present. The appellant is free to reserve as much time as you wish or as possible, but when the clock's out, we're done. Okay? With that, you may proceed.
Thank you, Your Honor. May it please the Court, Brian Holohan. I represent the plaintiff, judgment creditor, appellant in this case. Because we had the last word in writing, I'll be fairly brief. I've had some time to reflect on the Balistrieri case, which we brought to the Court's attention last week by way of a citation of supplemental authority. And I realized that I haven't been completely correctly stating my position on Rule 54G. I have up to now been saying it's inapplicable, and that's a poor choice of words. What I've been trying to get across is that because there were no attorney's fees claims pending when the May 22 judgment was entered.
Stop right there, because I noticed you had mentioned that in your opening brief. What do you mean that there was no attorney's fees claims pending? Because it's my understanding that at least in a pre-hearing memorandum or some type of memorandum that Sherry or William and Sherry had asked for fees. Is that not correct?
That's not how I read the record, Your Honor. Mrs. Lund filed a written response, but it said nothing about fees. Mr. Lund never filed anything.
But he came into the party late, right?
Yes.
So,
Okay,
so he
you-
and William and Bradford, I think, were brought into the matter late. Weren't in that initial salvo of pleadings, and then take us from there.
Okay.
Well, let's not leave this yet. I mean, okay, to take that further, let's assume you're correct, and it was not raised prior to the May 23rd, whatever the date was, May order. I'll just say the May 22nd order. Did you raise an objection? Did your client raise an objection to the lack of an attorney fee request in the Superior Court?
No, Your Honor. Why would we do that?
Well, the court entered fees. I mean, you didn't jump up and down and say, wait a second, there's been no fee request.
That would be the easiest way to deal with the argument, is to say they never preserved this request.
Well, I think I did say that. If you let me finish my thought, maybe my position would be a little clearer.
Well, I just said you noted that in the brief, but you didn't develop it, and I'm just wondering why.
Well,
go ahead.
I didn't develop it because it's the end of the story. Rule 58 says a judgment isn't final if there's a claim for fees pending. There was no claim for fees pending. So by definition, the judgment that was entered on May 22nd was a final judgment. And once a final judgment is entered, the ability to enter attorney's fees awards thereafter is limited. And none of those limited circumstances procedurally occurred here. There were no Rule 59 motion, no request that the order contain 54B language. The judgment was served on my opponents before it was signed and entered. They didn't ask that it be delayed, have 54B language. It's not
disposed of all. It's disposed of. Did it address all parties? Wells Fargo included.
Yes, it disposed of all of the parties.
Everything.
Everything. Yes, that's my point. And because
well, wait. The court goes ahead and awards attorney's fees, but when you objected to the attorney's fees, what did you say? Sorry,
I said you entered a final judgment on the 22nd, and your effort post-final judgment to do this isn't proper.
But you never said there's never been any request for fees. Why are we even discussing fees? Did the court? Are you telling us that counsel then the court sua sponte entered an award of attorney's fees?
No. They applied for attorney's fees post-judgment.
Okay, that was the first time they applied.
Without ever mentioning or preserving in any pleading that they would like fees.
Correct.
Okay.
And in my response, I noted that they hadn't done that. And Balistrieri has led me to conclude that my argument that 54G is inapplicable isn't quite accurate. Because they never made it pre-judgment under Balistrieri, they forfeited it. Now, my position has been and continues to be, and I respectfully think I'm right, Once he entered a final judgment, which he could do because there was no properly preserved attorney's fees claim, it was a final judgment, and they don't take up attorney's fees claims after judgment unless there's a Rule 54B judgment, which this plainly isn't, or it's a Rule 59 motion. This is why I keep going back to the Monty and the Lighting Mark cases.
Lighting.
Thank you. They were the law before the rule changed. But the reasoning applies in a situation like this, where a final judgment was properly, in fact, entered on May 22. And my position is that because it wasn't asserted beforehand, it was waived.
So if we look in the record and find that there was a mention of a request for attorney's fees in some pleading before the judgment was entered, or the purported judgment was entered, I'm not saying that's true. Something we'll look for. What happens then? Does your argument fall apart? Because this is a different argument than we were addressing before we walked into court today. Your argument now seems to be one purely of waiver based on the failure to preserve it in the pleadings, rather than all of this business about the timing of the judgment and amendment of it.
This is why I began by saying I haven't been stating my position very.
And I understand. But I'm just trying to clarify, if we do find that issue preserved in the pleadings, do you have any remaining argument?
Other than it was an abuse of discretion to award fees under these circumstances.
Okay, thank you.
And Judge, believe me, I have examined the record very carefully.
I'm not doubting. I'm just.
And I put in the responses at the time, you didn't raise this before the judgment was entered.
I just don't know what I'm going to hear in a few minutes.
Okay.
Yeah, okay. Well, let me ask you about the record, because I think you noted in the brief, I think that there was, Bradford had never actually filed. I guess they attached something on appeal that was not filed in the Superior Court. Their objection. But the court, I thought when the court entered its judgment, said that it had reviewed an objection lodged by Bradford. So how were we to read that?
Judge, I looked at the clerk's index of the record on appeal. It's not in there. The copy that you have attached to the brief doesn't have any conforming indication. There's no indication it was ever actually filed.
But there is an indication that the court looked at it.
Well, in fairness to my opponent, he showed up at the hearing with a filing that he distributed to everybody, but it never found its way into the record. And if it isn't in the record, it isn't in the record.
Okay, but if the court considered it, what are our options with that? Could we remand it on a very limited basis for the court to reconstruct the record and so that it accurately reflects what occurred? It seems a little bit silly that, you agree that the court saw it, you saw it. Why shouldn't it become part of the record?
Because it wasn't filed, Judge. I meant to. Isn't any form of legal standard I'm aware of.
But then we have the court considering something that was outside the record.
I think we call that error. If he considered something that wasn't in the record, he's not supposed to do that. For someone who seems to have been a stickler, if the commissioner considered something that never found its way into the record, he did something he wasn't supposed to, and that's why this court exists. And I don't have anything else unless there are more questions.
Thank you.
May it please the court, Your Honors. Greg Knepper for Sherry Lund and William Lund. Our intention, if the timing works, is I'll use about 10 minutes. My colleague, Mr. Shumway, will use our remaining time.
I think you know what our first question will be.
It's in the record. We preserved a claim for fees. Index of record number 159. It's the document I filed, titled Defendant's Hearing Memorandum. It's dated March 15th, 2013, before there was any hearing in this case. Reading the very last sentence, Sherry Lund also requests her costs and reasonable attorney's fees. Then I cite ARS Section 12-1580E. It's in the record. It's absolutely preserved. We requested fees right away in this case.
Okay, that's a request for Sherry. What? Well, maybe he'll address, council will address that, but where's the request from William or Bradford for prejudgment fees?
Bradford's request, I'll leave to Mr. Shumway. That's in the document that was not formally filed or shown as filed. As far as William, this is Jerry Lund. I was representing both parties once William was joined to the case. I accepted service on his behalf. I intended it to apply to their marital community.
Did the judgment actually say fees are awarded to William or just to Sherry?
I believe it said both.
To both? Okay.
Was there any objection to that? Was there a subsequent objection to the order? Did anyone raise the fact that the request for fees had not been raised earlier at that time?
No, Your Honor, and that was going to be the next thing I was going to bring up. I don't have the index number, but the date of the response to our fee motion is June 13th. I've read it at the time. I flipped through it again sitting here. The argument is about Rule 54G2 and whether the motion was timely, and also whether fees were appropriate for this case. There's no mention of the fact that the claim for fees had not been preserved. Of course, my position is it was preserved under the pleading that I just read from.
So the judgment goes in, the judgment is final, no appeals filed from it.
It's actually not a final judgment. I do think that's another point that bears correcting. The judgment that was signed just says it's order sustaining the objections to the writ and quashing the writ served on Wells Fargo. It does not dispose of this separate claim that Jules raised against Wells Fargo with respect to something to do with their garnishment answer. We know that claim was still pending because if you look at the minute entry from the same time, it talks about that claim and how it's going to be resolved, and then the index subsequently shows a stipulation to dismiss, presumably under some sort of settlement agreement.
So then you disagree with counsel saying that at the time the order entered, all matters were disposed of?
I do. They were resolved as far as my clients were concerned, but other matters remain pending in the case, and there's no Rule 54B certificate of finality. Now, I don't think that argument, I don't think I need that argument to be the case, even if this was a final judgment, and that's because the way I read 54G2, which is you get 20 days following the decision on the merits to move for fees, has interpreted by Britt v. Stephan, where this court said that 20 days continues to run even if there's a final judgment resolving the case. That Rule 54G2 has interpreted by Britt show that Monty and Mark Lighting are no longer good law, at least on this point. A trial court retains jurisdiction to entertain a motion for fees that was timely within the 20 days, even if there's an intervening final judgment. The argument was raised in the pleadings, although not discussed today, about whether my hearing memorandum is a pleading under Rule 7A. Rule 7A defines pleading as complaint, answer, counterclaim, things like that. And my hearing memorandum filed before the hearing doesn't fit any of those definitions, arguably. And I think the Ballesteri case, which Mr. Hollihan cited to the court in the subsequent brief, shows the error in that argument. That court said that a motion to dismiss will constitute a pleading for this purpose, because on a motion to dismiss, there's not any other filing that constitutes or fits within the definition of pleading. Motion to dismiss is filed with the court. All the parties have noticed that there's a claim for fees. So the purpose of the rule is served. And respectfully, it's the same thing in a garnishment context. A judgment debtor doesn't file an answer or a complaint. There's nothing that the judgment debtor files that would fit that definition of under Rule 7 of a pleading. But we file papers with the court. All parties were on notice, as I read, that we claim fees. And I think you interpret Ballesteri to apply in that context the same way. The legal question is, of course, is whether the application was timely. We believe it was. The other matters are for the discretion of the trial court. I think under the circumstances here, I'm not going to repeat the brief, but just the circumstances set forth, the trial court did not err or abuse his discretion in deciding that this case was appropriate to award fees. So we asked the award be affirmed, and we also asked for fees incurred on appeal under the same statute, 12-1580. It's my position that that should apply. This is an extension of the same garnishment proceeding and should apply for the same reasons it applied to the trial court. Mr. Honors, have any questions? That's all I have to say.
Thank you.
Thank you.
Good morning. I'm Jeff Shumway. I represent Bradford Lund, the intervenor appellee in this matter. I think the place for me to start is probably with this, our objection to garnishment. After, and probably the thing that needs to be pointed out first is that the first objection to our objection, and the first time the issue was ever raised, was in their reply brief, where they objected not to it being used by the trial court, not to it have been read by the trial court, but objected to it to being attached as an appendix to our Court of Appeals brief. And they claimed that that was inappropriate. If we
Was it filed?
It was filed, Your Honor. What happened was, and I guess this is part of the public record, after I received the reply brief, I went back and tried to reconstruct this. This was back almost a year and a half ago, somewhat new to e-filing. I filed 2 documents on May 13th. I filed our notice of appearance, and I filed Bradford Lund's objection. Both of those documents had upon them the following CV number: 2000-445923. The first document, the notice of appearance, was accepted for filing. And I received an email that in the Ray line, I said, all it said was Maricopa County Clerk of Superior Court. And if the court's interested, I have copies of these for the clerk, and you can see them. You can see on this that on the documents list, the objection opposition was filed. Then later, it appears on the 14th at 4 o'clock Mountain Standard Time, I received another email which somehow I misread that said that the second document was rejected. And apparently, I know now, it was rejected because it had the document number, the case number 20000, instead of the appropriate case number 0000, which I later learned had been a new case number assigned to the case because of fears about computer glitches dealing with the changeover from 1999 to 2000. So the document was filed. There's been a little bit of wave.
Just to be clear, the document was, you attempted to file the document. It actually wasn't filed.
Fair enough. I attempted to file the document. The clerk rejected it. Probably the most important part about this, Your Honor, is had anyone said anything about it, it's an easy error to correct. I print out a new front page, I change a 2 to a 0, I hit file. And that's where it's left us. If we assume that appellant is right, that it was inappropriate to attach it to my appeals brief, where that leaves us is what happened in front of the trial court. Well, what happened in front of the trial court was that it was handed to the trial judge. It wasn't handed the day of court to opposing counsel. It was emailed to opposing counsel the night it was filed, 2 days before court. It was emailed to Mr. Knepper that night. We show up in court. The court relies on it. It was then relied on in my application for attorney's fees, because my application for attorney's fees said, here's the history, that's all laid out in our objection, and it was attached as an exhibit to our reply in support of our application of attorney's fees. Through all of that, nobody said, hold it, court, you can't consider it. It wasn't filed appropriately. That's a problem for 2 reasons. First of all, you can't make new arguments in the Court of Appeals that weren't made in front of the trial court, which leads to the second reason. The reason you're not allowed to make new arguments at the Court of Appeals is it deprives both the parties and the trial court of the opportunity to remedy the situation. Had this been raised in front of the trial court had lots of options. It could have said, Mr. Shumway, go hit send again and make sure it gets done right. The court could have said, Mr. Shumway, you blew it, I'm not going to consider it. And if the court had done that, we would have a clean record. Or whatever the trial court had had. But we would have been able to address it in front of the trial court rather than being here at the Court of Appeals trying to figure out what happened after the fact. My error, I admit it. I apologize to the court for the error. I've learned a lesson in this. I now check every email. I now go online and print out a conformed copy. But it doesn't help us other than to say you can't raise things for the first time at the Court of Appeals. It needed to be raised in front of the trial court. So let me just add my, unless there's further questions on that topic, let me add my, it seems to me that the issue here is a 54B issue. Was this a final judgment or not a final judgment? There's no 54B language. The court conceded that there were still proceedings involving Wells Fargo Bank. It didn't resolve the entire case as to all the parties. That means that the May 22nd order was nothing more than a signed order. It wasn't a final judgment. Had it been a final judgment, we still filed within the 20 days. And we're still within the Brit rules. And if you look at what happened, we followed the Brit case explicitly. We went right down the line, did exactly what we were told to do in that instance. Let me quickly address the issue, and perhaps for the first time in my career I'll be done with time remaining on a clock. Let me address the issue of the merits of the attorney's fees. Again, all that was raised at the trial court was this idea that we were only fighting over $4,500 or $4,800, and Mr. Shumway charged more than that. In fact, I charged substantially more than that. The court did not award us all of the attorney fees that we sought, but the court had good reasons for awarding fees, including the fact that we had sent a letter saying, here's the law, here are the documents. If you'll withdraw the writ, we won't ask for attorney's fees. Brad wasn't trying to expand litigation. He wasn't trying to take advantage. He just wanted to be left alone and get out. But they ignored the letter. They said they were too busy. They then forced us to file a brief, the memorandum, to attempt to file the memorandum. We then showed up at court, and the first thing was, oh, they're right on the law. The court was fully justified. There is no attack on our attorney's fees other than it's bigger than the amount in controversy. We provided detailed attorney's fee statements. They had the opportunity to go through line by line and say, this is too much, that's too much, and they didn't do it. The court exercised appropriately its discretion. And again, the idea that somehow we missed our opportunity to get attorney's fees because it wasn't raised in a pleading ahead of time is an argument that wasn't made to the trial court. They filed a 4-page response, 3.5-page response, and their entire response was this idea that we should have filed a motion to amend the judgment instead of an application for attorney's fees. If they lose on that issue, which is the only issue in front of the trial court, then Brad should have the order affirmed and he should be awarded fees here. Unless there's questions. Thank you, Your Honors.
Thank you.
May it please the court. If Mr. Knepper's right, I stand corrected. He did, however, acknowledge that Mr. Lund didn't make a claim, and the judgment is to them jointly. So at a
Well,
minimum,
in
the
a
judgment.
community property state, I mean, the reason that he had to be joined was that they were, there was a community property dispute, isn't it?
No. Mrs. Lund is the only defendant. It's a separate obligation of hers.
No, but she's the only, you say defendant, you mean judgment debtor.
She's both.
I thought William objected because he had, no, what was the basis of William's objection?
She filed a pleading saying that he had to be joined to the proceedings because his name also appeared on the account.
Well, but then ultimately the reason that the garnishment was unsuccessful was that it was her premarital debt, and she demonstrated that the judgment couldn't reach funds from the source in the account, right?
Not quite, Your Honor. What they persuaded the commissioner was that all of the monies in the account belonged to Brad and therefore could not be executed upon. All three of them have the name on the account. They produced records showing that 3 years earlier, Brad put some money in the account, and it roughly matched the amount of money in the very last statement they produced, and they argued that it was his money. And the reason I was asking for more time was to get some records to make sure that was the case, and if it was, we would have let him out. But the point is, Mr. Lund spent his money because Mrs. Lund has admitted she has no money defending her, and because he never preserved the objection, the judgment should be vacated. Now, I want to be very clear on something because I'm being accused of changing horses in the middle of the stream, and I don't think that I am. My position has always been, and it continues to be, that the May 22 order was a final judgment because there were no pending attorney's fees claim. Now, as to Mrs. Lund, I may stand corrected on that, but certainly
Well, the judgment isn't final with regard to some people and not others unless there's 54B language, which there isn't. So if you stand corrected on Mrs. Lund, then doesn't that divest the judgment of finality?
I can't immediately think of a reason why it wouldn't,
Fair enough.
and unless there are more questions.
All right. Thank you all. This matter is now under advisement. We'll issue a written decision in due course, and the court stands adjourned.